Professor Mossoff, where do we find the sweet spot in protecting patent holders and also protecting against frivolous lawsuits?
Thank you for that question, Congressman, because that allows me to get to, I think, a really important point, which is that you don't have any actual rigorous studies that follow standardized norms and statistical analysis that have concluded anything about widespread systemic abuse of patent litigation. So no studies on that. Moreover, the debate and the discussion, even about the Eastern District of Texas, is just as much about patent litigation more generally, is really infected with a lot of just rhetorical epithets, like the term troll. Everyone thinks of troll as a bad person, but when you look at the definitions of what people include under those terms, such as the definition used by Unified Patents used in Professor Chen and other papers, it includes individual inventors, it includes startups who have patents, it includes small businesses, it includes manufacturers actually who sometimes license. It includes licensing companies, long-established drivers of innovation in this country. And this is exactly licensing, not manufacturing, is a key component of what has been the success of the U.S. patent system in driving our innovation economy for well over 200 years. This has been repeatedly shown by economists and historians that the licensing activity in secondary markets and patents was fundamental in the 19th century and the 20th century. It was used by Thomas Edison, Nikola Tesla, and others. So these are the people that we are now condemning as trolls.
I thank the gentleman. I've lived a long time. I never thought I'd hear Edison called a troll in a hearing and before Congress. With that, we go to the gentleman from Georgia, Mr. Johnson.
Professor Mossoff, what do you mean when you say that the T.C. Heartland case is just one step in an incremental erosion of patent rights and the impact that that has on our patent system in this country and our ability to be competitive as a country?
Thank you, Congressman, for the question. The United States Supreme Court has been engaging with the patent system in terms of hearing cases at a rate that we have not seen for well over a century. And a substantial majority of those decisions, contrary to a couple of cases identified by Mr. Thorne, have come out in terms of weakening, eliminating, or narrowing patent rights. Whether you're talking about making it harder to get injunctions in eBay, harder to license and engage with commercialization through MedImmune, through Quanta and the recent decision in Impression Products, whether you're talking about the 4 cases that have substantially restricted the ability to obtain actual patents on innovation. And the statistics are showing more and more that this is a rising concern for the innovators who are driving this country, the inventors and the heavy R&D intensive companies that produce patented innovation. Just to take a quick moment as an example to show, I have a paper coming out this month where we talk about 1,700 patent applications on the same invention. Patent applications were filed in China, in the European Union, in the United States. All 1,700 patent applications were granted in China and the European Union, and they were denied in the United States for being unpatentable inventions under the new Supreme Court rulings, the 4 cases that address the 101 issue, patent eligibility. And these are inventions on radical diagnostic methods for treating cancer, diabetes, and whatnot. So we've repeatedly seen this, that inventors are going overseas now and are obtaining patents in other countries such as China and Europe. And if that's the case, that is where their venture capital funding will go. That is where businesses will be set up, manufacturing and licensing will occur, and they will benefit from that with their economic growth and their innovation economies, just like the United States did with stable and effective property rights and innovation for the first 200 years of this country.
I yield back.
I'll now note that I've now heard that China is the country we're going to base the high mark of patent tolerance on. Every once in a while I pull this off the wall and bring it, and I know that you all can read from here. This is patent number 1, bearing the signature of both George Washington and Thomas Jefferson, then I guess Secretary of State. And anytime somebody wants to talk about 101 and Alice, I'm always reminded that it's a 227-year-old standing of what Thomas Jefferson believed it should be. And I always ask a question, and maybe I'll ask each of you that question as my opening salvo. After 227 years of 101 being what Thomas Jefferson thought it should be, have we had too little innovation as a result of that standard? Mr. Anderson, in your non-patent opinion?
I think the United States of America is doing pretty well in that category.
Professor Chen?
I would have to agree.
We're on a roll. How about it?
Mr. Chairman, our patent system has been fantastic. Unfortunately, that very first patent, which is for a method of making potash, is probably now not patentable under the patentable jurisprudence decisions that the Supreme Court has handed down.
You know, with the knowledge of the time and the innovation of the time, I think even the patent number 5, the improvement of rye whiskey distillation, probably would still be patentable. But one would have to go back and look at those of ordinary skill in the art at the time, including George Washington as a distiller. Mr. Thorne?
Our patent system is second to none, and innovation is what's going to drive our economy.
And by the way, Mr. Thorne, you're now my favorite witness, because I think you said Patent Pilot was great about 20 times. And as the author of Patent Pilot, I'm very proud that it is being used. We have extended it. And the vision always was to have every judge who regularly takes cases and chooses to take them have the expertise he needs. And I might note that Justice Breyer also has the similar opinion, which is we must maintain a robust ability to decide cases closest to the defendant, or there is no reason to have cases decided in district court. And Justice Breyer always muses that he considered, instead of the Fed Circuit, he considered just simply moving it to D.C. and having a single court here. And if we had a single court here, it would be a court, Article III court of jurisdiction. And for some reason, just as a school kid in me, Marshall, Texas, 23,000 people, God bless God for putting it there. There's a special reason. Or Washington, D.C., which one seems to be more logical considering the expertise? But leaving that aside, Professor, since the University of California files a lot of cases through their proxies in Marshall, Texas, you mentioned the little guy and so on. And you mentioned universities, and I found that interesting, because why is it that the University of California doesn't file or cause their licensees to file in California?
I don't know.
Could it be that, in fact, Marshall, Texas just seemed like a great place to win?
You need to ask someone from the University of California, but as a professor, I don't have any particular insights or expertise about how patent litigation and venue choices should work. What I would think the Congress should particularly do in considering these issues is speak with the people who are the primary users and creators of patented innovation and commercialization of in this country. As I mentioned, the individual inventors, the startups, the small businesses, and the research-intensive companies in the biopharmaceutical sectors and even in the high-tech sectors, and speak with them about what is efficient and best secures their property rights.